So what we filed just after midnight this morning, Anderson, was a preemptive motion. And what we've asked for is a number of things. We've asked for a 2-hour deposition of the president, a 2-hour deposition of Michael Cohen, some limited document requests where we can ask for specific documents to be produced, and then we want an expedited trial date on the issue as to whether an agreement was actually entered into. Now, why is that important? Because before their motion to compel arbitration can be heard, a fundamental question must be answered. And that question is whether there was an agreement to begin with. It's one thing, Anderson, to lie to the press. It's another thing to potentially perjure yourself. If the motion is granted, Anderson, I can envision us taking the deposition of Michael Cohen and the president within 30 or 45 days of the end of April.
After a judge denied his motion to question Trump and Cohen under oath, calling it untimely because it was filed too early in the process, Avenatti plans to refile
We've heard, Lawrence,
that motion.
For the better part of a month now that this was a rock-solid, airtight agreement. You've got David Schwartz out there talking about what an excellent lawyer Michael Cohen is and how this was a model NDA. It's a lot of things, but there is no way in hell it's a model NDA. This thing is a piece of trash in reality, and everybody knows it, and any legal analyst that looks at it will tell you the same thing, who's not biased. But that's what we've been hearing. And now what we have is we have a principal party to the agreement who admits on camera that supposedly he didn't know anything about a principal term of the agreement. Well, that means he didn't know anything about the agreement, which means there is no agreement. So all of this chest pounding and these threats about how they were going to bury my client and they were going to seek $20 million and they were going to go on an extended vacation with the money and all of this other buffoonery that we've heard for the last few weeks, that all goes out the window. You can't enforce an agreement where one party admits that they basically didn't know anything about it. It's an absolute joke, and I also think it calls into question the veracity of the statements all along the way, and is going to provide a further hook, Lawrence, for us to be able to depose this president and Michael Cohen, and we're going to make that motion again. We're going to renew that motion on Monday, and we're going to see what the court has to say. And I will tell you this. In the event that we get a 2-hour deposition of Michael Cohen and a 2-hour deposition of this president, I am highly confident that their statements are not going to hold up under cross-examination by me, period.
Lawyer Michael Avenatti is sending this letter to Treasury Secretary Steve Mnuchin, requesting that he publicly release a bank's suspicious activity report related to the $130,000 payment from Donald Trump's personal attorney, Michael Cohen. Banks must file such reports about unusual transactions they suspect have no business or apparent lawful purpose, or that involve funds that may be derived from illegal activities designed to hide illegal activities or to evade regulations. Cohen says he paid Daniels to keep quiet about an alleged affair she says she had with Trump in 2006. Avenatti also wants Secretary Mnuchin to release other documentation related to the payment, which he argues is an illegal campaign contribution.
You're saying it had absolutely nothing to do with the campaign, that it was just a coincidence that this was in, what, 11 days before the presidential election?
This is when the settlement took place. The law is pretty clear on this, okay? If the bottom line is if it's for reputation, business, family, to protect those things.
Right.
Then,
but that could have been done in 2000.
By the way, thank you for supplying that picture.
Well,
that
that's not the last one. That's not the last picture.
Oh, yeah. Where is it?
Buckle up.
Where?
That's right.
One simple question. Where do you go from here with this?
Yeah.
Well, again, as I think we've made clear, I mean, we're only getting started. We are going to get discovery in this case. We're going to get to the bottom of what Mr. Trump knew and when he knew it and whether he knew about the agreement and where this $130,000 payment came from. And I think, as you saw, the expert stayed on 60 Minutes. This has serious consequences. This just isn't about sex in a hotel room in Lake Tahoe. It's not about that. This is about the cover-up. It's about Mr. Cohen lying to the American people about this agreement and the fact that Mr. Trump didn't know anything about it. The idea that Mr. Cohen drafted an agreement entirely on his own without any knowledge of Mr. Trump, and he never expected Mr. Trump to ever know anything about it, then why did he put Mr. Trump in the agreement? And why is there a signature line for Mr. Trump if he never thought Mr. Trump was ever going to know about the agreement? It makes no sense. This is a lie, but it's not a good lie, and we're going to get to the bottom of it, and we're going to blow it out of the water for the American people. And when the truth comes out, the truth is going to be very, very ugly for Mr. Cohen and the president.
What's the level of confidence you have in maybe deposing Donald Trump at some point?
Very, very high.
Really?
Really. We're not going to need much time. We're going to need probably 2 hours or less. These are very straightforward questions. American people deserve to know what happened with this agreement, whether Mr. Trump knew about it, whether he knew about the $130,000, and what happened in connection with that payment. She wants the lies. She wants the lies and the deception and the games to stop. This is a very simple matter when you really get down to it.